Hello, Law Nerds. Happy Friday. It's September 19th. Everyone makes a motion for new trial after a conviction. If there's an acquittal, there's nothing to ask for a new trial on, right? Because you don't need to ask for a new trial. You're done. But if there's a conviction, the first step would be that motion for new trial. And you see it during trial too. So the prosecution does their case in chief. Then the defense is going to make their motion to dismiss or motion for judgment of acquittal. Depending on what jurisdiction you're in, they will call it different things. I believe Florida calls it a JOA. Other jurisdictions call it motion to dismiss. I will use the two interchangeably that happen at the end of the prosecutor's case. Oftentimes you will see the defense renewing that motion. And we saw that in Florida versus Donna Adelson as well. We saw the defense make their motion for judgment of acquittal. Then they did their case in chief. Then they renewed the motion for judgment of acquittal. And we're like, hey, Your Honor. So I know that you said no, but maybe now? Please, can we do it now? And the judge was like, yeah, still no. And so the motion for new trial is not the same standard as a motion for judgment of acquittal. It is the step before you're getting another court to take a look on appeal. So it is asking the trial level court to evaluate whether or not a new trial should be granted based on reasons, sometimes vibes. Sarah Boone's argument basically but Your Honor, not intentionally, new trial. And the judge was like, yeah, no. We saw the motion for new trial be pretty extensive in the Murdaugh case. And that motion for new trial has gone up, down, all around. So that motion for new trial based on Courthouse Becky is still going through the appellate courts because of Courthouse Becky before we get into all of the appeals. They're still in the motion for new trial. Now, when it gets to an appeal, generally the result on appeal is also a new trial. So it gets a little confusing. I think the easiest way to simplify it is what judge is evaluating the motion and what are they considering? So the motion for new trial is being evaluated by the trial judge, saying, hey, judge, you made some decisions. You've had a minute to think about it. Did you change your mind? Maybe we should have a new trial now. Don't make us go to the appellate court and tell them that you made these decisions and they should change your mind. Do motions for new trial often go very far? No. Why? Well, they're telling the same judge the same essential thing that they said during their motion for judgment of acquittal or motion for dismiss. It's just an extended version of that, but it's also kind of a preview of what will go to the appellate court. But these are decided and argued by the attorneys in front of the trial judge, not in front of the appellate judge. So hopefully that distinguishes the difference and makes sense, because that's what we're going to cover today. The title of this already adds in one more quirk that we haven't mentioned. It's not just a motion for new trial. Defendant's motion for new trial and for leave to interview jurors. So we're not just looking at, hey, Your Honor, can we get a new trial? We're also going to see finger pointing at the jurors. I would guess that it's the jurors that spoke out, because that's what we've seen in other trials. And we've seen jurors be interviewed. They were interviewed in Murdaugh. We know that jurors were interviewed in the Maya case just based on everyone else who covered it. And then there have been other cases where jurors have been interviewed. We saw that in the Maxwell prosecution as well. Jurors can talk after trial. It doesn't mean you get to interview them. So we are going to jump into all of that. We're going to keep in mind that the standard for a new trial, especially from the trial court, is quite high and hard to meet. That's generally not what happens. The leave to interview a juror, that standard varies by jurisdiction and varies quite a lot. Motion for leave to interview jurors. The title has a footnote. Footnote 1. Although the jurors have identified themselves through social media or media appearance, the court previously ordered the parties to refer to the jurors by their juror numbers. I mean, that's fair. So, Your Honor, we're not referring to the jurors by name. You've asked to refer to the jurors by number. We're referring them by number. Fine. I don't think that's the right place for that footnote. I am not an English major by any means, but I feel like footnote 1 should have gone under number 3, Adelson's request to interview juror 5 and 7. I think the footnote just would have gone there, because then it describes why you're calling them 5 and 7, but whatever. It's on the title. Paragraph 5. In the court's preliminary instruction to the jury, the standard instruction was read. You are not permitted to communicate about this case with anyone, including your spouse, family members, friends, neighbors, or even your fellow jurors. No communication includes no in-person telephonic or electronic communication, such as emailing, texting, posting information on social media, or a website, or any other form of communication. Right. You can't communicate about the case. Fair. Will there be a state response? Yes, the state will file an opposition and then there will be a reply. And then there will probably be a court date set to argue this in court. I imagine the court's not just going to rule on the pleadings. During the trial, after the trial, can you talk? Yeah, they can talk after the trial. And I didn't see any information that the jurors spoke about the case during the trial. If that's true, I'm interested to hear what they have to say because that should follow next, right? The next sentence immediately says, subsequent to trial. Okay. Subsequent to the trial, juror number 7 went viral on TikTok concerning her jury service. She revealed that she posted to TikTok during the trial. She's allowed to do that. All of you are like, no, it definitely didn't go viral. She posted and people talked about it does not equal viral. In her TikTok, she revealed that she posted to TikTok during the trial. In reviewing juror number 7's TikTok account, the undersigned identified she posted on TikTok that she was elected as a juror on August 26, 2025. You're allowed to say that you're on jury service. Asterisk. I have not seen whatever TikTok they're referencing, and lawyers are going to take everything in the light most favorable to their client. So just take it with that information that this is advocacy. What I will say is that if you come home, you're allowed to come home and be like, yeah, I'm on the jury. You're allowed to call your employer and be like, hey, I'm going to be on jury service. And if you post frequently on social media, I don't see anything improper about saying, hey, chat, I'm going to be on jury duty, so I'm not going to be posting a lot. There's nothing wrong with that. So the juror posted on August 25th that she was selected as a juror. With nothing more, that's not improper. A flash drive with this video will be provided to the court as the undersigned has been informed that particular TikTok was deleted by the juror. Well, that's frustrating, but that actually might be grounds to have an interview if it's since been deleted, to ask, what did you post to social about this case? Because you're not allowed to talk about the case. Saying you're a juror is different than saying, oh my God, I'm a juror on the Donna Adelson case, follow for more. And some of you are saying she said she was a juror, but not what case it was. And all of you are saying it wasn't deleted, so fine. The undersigned seeks to interview juror 7 concerning her social media activity during the trial. Without more, that's not going to be enough. Juror number 5 appeared on the podcast Surviving the Survivor. You're allowed to go on a podcast after the trial. During his appearance, he revealed he considered how Ms. Adelson reacted to the evidence and testimony admitted during the trial. Footnote 2. Based on the court's numerous admonitions to Ms. Adelson during trial, she was prohibited from expressing any emotion during the trial. Okay. The next sentence says, although he subsequently stated he, quote unquote, obviously did not consider that during deliberations, that he considered Ms. Adelson's reaction whatsoever as concerning as her reactions were not evidence and are extrinsic or external rather than that which inheres in the verdict. So what you're saying is they're arguing he considered Ms. Adelson's reaction to the evidence and testimony, though said he obviously didn't consider it. If he said in the interview he obviously didn't consider it, why is your argument he considered it? Even in the next sentence, you're undercutting your argument. Noticing and considering aren't the same. The fact that the defense immediately has to walk it back and say, okay, but he admitted that he obviously didn't consider it during deliberations, then he didn't consider it. Because it must be clear enough that the defense can't argue another interpretation. Because if the defense could argue another interpretation, they would. Their own language feels like a stretch to me. Juror misconduct. According to the Florida Supreme Court, quote, potentially harmful juror misconduct is presumptively prejudicial. So their standard is different than the standard in South Carolina. We talked about this a lot with Murdaugh. The standard is closer to the federal standard, presumptively prejudicial. So the defense doesn't have to prove that it did cause harm. If there is potentially harmful juror misconduct, then it is presumptively prejudicial. Prejudice doesn't need to be shown. However, how do they define potentially harmful misconduct? They go on to say a party seeking a juror interview, quote, does not have to conclusively establish that the alleged juror misconduct occurred and, quote, actually prejudiced the case. Rather, they're quoting case law on this, quote, it is only necessary that the party establish a basis for an inquiry or grounds the party believes may exist. Once in proper contact, that's the courthouse Becky situation, that's not here. Once in proper contact or juror misconduct is established by juror interview, the moving party is entitled to a new trial unless the opposing party can demonstrate that there is no reasonable possibility that the juror misconduct affected the verdict. Where's the misconduct, though? If the juror misconduct is confirmed from the juror interviews, the undersigned will request leave to make more extensive arguments concerning why the juror misconduct in this case warrants a new trial. But what is the standard that gets you an interview? None of this talks about that. We're going to have to wait till the state responds to find out what the standard is, because they didn't cite the standard to get an interview, only the standard to find misconduct and to throw out the trial and get a new trial. But you're missing a step. And then they've moved on quickly. The state presented evidence and testimony over a period of 6 days. The defense had requested 4 to 5 days for its case. On the second day of the defense case, the court demanded, I was wondering if this was going to come up, the court demanded that Ms. Adelson decide whether she would testify. They left out a little bit of this, didn't they? One of the key things they left out is that there was a 3-day weekend in between there. I'm sure the state will point it out. But the defense had requested 3 to 4 days is what I recall, but they probably have the record because that's what I took notes on. But they did ask for more time than they used. On the second day of the defense's case, the court demanded that Ms. Adelson decide whether she would testify. Both counsel for Ms. Adelson as well as Ms. Adelson herself repeatedly advised the court that more time was needed to discuss the evidence admitted and the pros and cons of testifying based on the volume and substance of the evidence admitted during trial. All of these things could be done prior to trial. Why? Because nothing was new. But again, I do not have the perspective of a defense attorney. Perhaps I am unaware of the intricacies that sprang up during this trial that were unknown to the defense before this trial began. Things change. Trials are dynamic. Both counsel for Ms. Adelson as well as Ms. Adelson repeatedly advised the court that more time was needed to discuss the evidence admitted and the pros and cons of testifying based on the volume and substance of the evidence admitted during trial. They didn't say it quite like that. In order to make a knowing and intelligent decision in what was probably the most important decision in her life. That is what they are keying on, that her waiver of her right to testify was not a knowing and voluntary waiver. I think that argument might be something that they explore more when they get to the appeal stage of this. I don't think the court is inclined to change their mind on their own ruling. The appellate court might see it differently than the trial court. I don't see the trial court changing their mind. I see him saying, you had a 3-day weekend. The evidence that came in is consistent with the evidence in Charlie's trial, this trial. So you knew what evidence was coming in. You interviewed all the witnesses that the state was bringing. There was no, quote, new evidence, and the trial had already been continued twice. So Donna knew what was coming in at trial, and the court broke early the day before. But an appellate court might say, you know what? She needed more time. And if the appellate court decides that she needed more time, it will go to retrial. And if it goes to retrial, do you think she would testify? I still think she wouldn't. I don't think her testimony would have changed things. I think the way the state got into Charlie's double extortion plot threw all of this off. And I think that's what they needed to really address together. And I think they probably needed to evaluate what the jury thought of the jailhouse informants. I think those are the two big things. We'll see. But that's what they're going to argue on, I think, at appeal too, that this was not a knowing and voluntary waiver on Donna's part because she didn't have enough time. I think it was the right decision, though. I really do. At the end of the 18-page motion of the defense asking the judge to allow them to interview jurors and for a new trial, I think their arguments on the facts and the jury instruction in the law is probably one of their strongest arguments for the motion for new trial. The motion that they're going to make on appeal and that they've made here with regard to the defendant not having enough time to make her decision to testify or not is, I imagine, going to be one of their primary arguments on appeal as well. It's unlikely to me that the trial court, given the totality of the circumstances, is going to change their mind. I imagine Judge Everett is going to say, we had a 3-day weekend. We broke early. This trial had been continued. The evidence that came in at trial was similar to the evidence at the previous trials. You knew all of this and you were still asking for more time, and more time was not needed to make the decision. You knew when we broke for the 3-day weekend that this decision was imminent. I'll be interested to see what the Court of Appeals thinks of that argument, because I don't think Judge Everett is going to be persuaded by it. I think his words were to the effect of, you knew this time was going to come. You knew this decision was going to have to be made. The time is now to let us know what you are going to do. You knew.
Concerning those rights as to whether you will remain silent or whether you will testify, have you made a decision concerning this matter?
I haven't. I'm not prepared to make that decision. This decision affects the rest of my life.
Mrs. Adelson, you're in the same position as every other criminal defendant who faces trial. Ultimately, you must decide whether you will testify or whether you will not. I cannot make you testify. Your attorneys cannot make you testify. But ultimately, you must choose whether you will testify or not.
What's interesting to me is they're asking to interview the jurors. They didn't line out the standard that would allow the court to interview the jurors. They just put in the legal standard of if the jurors disclose that there was any impropriety when they are interviewed, then what happens next. But they didn't include any standard about when jurors are interviewed or how the court evaluates jurors being interviewed. I imagine we'll see that in the state's response. They were arguing that the jurors should be questioned about the 4-person posted on TikTok saying that they had been selected for a jury and that they should be questioned about that. You're allowed to say that you are going to be on jury duty and might be unavailable. You can't talk about the case. And nothing the defense argued says that the jurors talked about the case before they deliberated. And then they argued that the other juror who gave an interview said that they looked at how Donna was responding to things but didn't consider it, but that it's improper to consider it. So they might have considered it, but we need to ask them that they might have considered it. Okay. I don't know what standard the court will use to determine if there will be juror interviews. I'm not persuaded that they need juror interviews at this point, but could I see the court saying abundance of caution? Let's bring in the juror and being like, hey, did you talk about this case before you deliberated? No. Okay. Done. We'll see. I want to know what the standard is. Hopefully the state will line it out. So strongest arguments, I think, for the defense, though I don't think they'll be persuasive on a motion for new trial, are going to be Donna needed more time to decide to testify, and the defense will keep arguing there wasn't a knowing involuntary waiver, and therefore she did not adequately waive her rights. And 2, that the totality of the evidence does not indicate that Donna knew or took action before the murder for the solicitation charge and the principal charge. It's a technical legal argument that might not go very far with jurors, but might go somewhere with a court of appeals. I'm interested to see how the court lines out their totality of the circumstances. With all of that, the state's going to respond with their opposition. We'll get a reply from the defense, and then we'll get this set as a hearing at some point on a hearing for motion of new trial. I don't know if the court will set this before the next court date in October, because they have a status conference set for October. Maybe they will, maybe they won't, but I will tell you in the Lawnerd app when the next court date is so we can watch it together, because I very much want to know. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Lawnerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.